Please rise. The Justice of the Appellate Division, Supreme Court, First Department, bldg, all persons having business with the Appellate Division, draw near, give your attention, and you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have some hours, over 4.5 hours of argument time requested this afternoon, so please bear that in mind. As I call the calendar, remember that we have your briefs, we have your record, we're fully familiar with the facts of the case, so ask only for the time that you'll absolutely need to make the most important arguments in your case. First case is People versus Michael Roman. 4, 1, and 4, thank you. Oputa versus New York City Transit Authority is submitted. Oh, I'm sorry, I didn't see you stand. Do you want to argue? Okay, we'll take a submission. Thank you. Madochi F. against Didon M. Submitted. Scott versus Lyceum Theater. People versus Jimmy Frazier. 4, 1, and 4, thank you. Rodriguez versus Quick Realty.
Respondents, Your Honor, good afternoon. With me is counsel admitted to argue pro lapice, and we respectfully request 4 and 1.
Thank you. Did I see? Okay. And I just want to double check, for the appellant, you said 5. Did you want rebuttal or did you just want 5? 5. Okay, fine. Contre versus Building Oceanside. This is Contre versus or bldg Oceanside. Are you the appellant or the respondent? Oh, I see. And there's no appellant. Do you want to argue? Okay. 2 minutes? How about 2? And we'll see if you need some extra time. PJSC National versus Piragova.
7 minutes and 3 rebuttal. Respondent.
We'll do 6 and 2 and 8. Thank you. People versus Alejandro Campis. 3, 1, and 3. Thank you. Alvarez and Marcel Valuation versus Solar Eclipse. Okay, thank you. 6, 3, 4, and 4. Stanley versus 1854 Cedar Avenue. 5, 2, and 3. Actually, on the previous case, 6, 3, and then you will determine. I said 4 and 4. I'm not sure that that's the distinction you wanted. Okay, fine. 6 and 2. Gomez versus Samaritan Daytop Village. 3 and 1, 3 and 3. Thank you. Williams versus New York City Department of Transportation. Is there a respondent here? I don't see. Do you want to argue? 2 minutes in a submission. Thank you. Bank of New York Mellon versus Davis is a submission. First case is People versus Michael Roman or Roman. I'm sorry, there's one additional case. It's an original proceeding. Rashid versus O'Neill Levy is submitted.
Good afternoon, Your Honors, and may it please the Court. Rebecca Martin for Appellant Michael Roman. Your Honors, the Level 3 designation in this case was a significant overassessment of the risk Mr. Roman poses to society. The 110 points he was assessed put him just at the cusp between a Level 3 and a Level 2, and he demonstrated by a preponderance of the evidence multiple significant mitigating factors that militated in favor of a downward departure.
Why would a downward departure be appropriate here where all of the mitigating factors seem to have been taken into consideration by the risk assessment and all of the factors, I should say, seem to have been taken into consideration by the risk assessment and to have been considered by the judge in this case? Why would there be an abuse of discretion here?
Your Honors, we're not arguing an abuse of discretion. That's not the standard that is applied here. Rather, you have the power to exercise your own discretion to review the record again. We argue that, in fact, many of these mitigating factors are of a kind or to a degree that were not taken into account by the RAI. Most significantly, Mr. Roman's dedication to an exceptional response to treatment. That is a factor
What was exceptional about it?
Your Honor, the most exceptional thing, I think, was really the demonstration. I think the moment that demonstrates his exceptional response best is when he chose to stay incarcerated, so continue to pursue programming rather than pursue parole, despite the fact that he'd had perfect prison disciplinary record, all this programming. Really, it seemed likely that he'd be granted parole. And that demonstrated not just his dedication to treatment, but how much he'd already learned, his ability to self-reflect, to say, what are the options in front of me? Which choice will be best for my continued rehabilitation, my continued sobriety, to accurately make that assessment and take that choice, even at a great sacrifice to himself, staying incarcerated.
This, it really has to be to a degree not considered by the parameters here. Why is this to a degree? I understand for his own benefit, he decided to stay in longer so he could do this program. What makes that so significant here that it wasn't considered at all and it should be, or it wasn't considered to a degree that we should now give a downward departure?
Well, Your Honor, I think that level of dedication and what he demonstrated, if that is not exceptional, I'm not really sure what is. And it is contemplated that exceptional response is something that exists to a degree not found. And I also think it's really—
Is he in a program now?
Your Honor, I am not sure if he's actively in a program, but he is still sober. He has remained sober for 5 years. He has not reoffended. And I think it's also important to note that at the time of the hearing, he had been in the community for 5 months, which obviously is not a super significant amount of time, but it was during those 5 months he had moved from Pennsylvania where this crime happened back to New York. He'd resettled in New York. He was taking care of his mother who had cancer. These are all incredible stressors. And so I think the fact that he demonstrated during that time he stayed sober, I think all the facts in front of the court at the time really demonstrated that he did have this exceptional response to treatment, as well as these other mitigating factors that I had discussed, such as his age and his remorse. And
It's interesting that you raise the age issue because in some ways, to me, the fact that he argues his age means that he won't reoffend is a very weak argument, given that he was 57 years old when he offended in the first place. It's not like I understand that argument when you have a very young person who offended and has learned better, but he was 57 when he committed this pretty heinous act. Why should we think that he's now old enough to know better?
Your Honor, the social science just shows that really no matter the age of when you commit the offense, just older offenders are less likely to offend. But I also want to emphasize—
I'm sorry, there's actual social science evidence showing that somebody who commits a sexual offense at 57 will know better in 10 years?
It's not about knowing better, it is just an inclination. But I also want to emphasize that that is not the core of this argument. The real core is, that's just one additional factor, but the real core is that this act happened because he was very drunk after a lifetime of his addiction. No one denies, the severity of this crime, least of all him.
Counsel, even if we were to accept your arguments under factors 1 and 2, there's a third factor, which is weighing of the mitigation that you're putting forth versus the totality of the circumstances, dangerousness, and recidivism. Like, where's your argument on that? Because honestly, you've really walked back a lot of that.
No, so the argument here is, yes, the crime that he committed, if you were to commit it again, the harm would be really high. No one argues that. But you also have to consider what is the likelihood he will actually reoffend. And the core of this crime happened when he was drunk, and he committed himself totally to rehabilitation. It's the rehabilitation on the totality of record is really what we're arguing here, that there's such a low likelihood of reoffense that a level 3, the highest possible level, wasn't appropriate. And
Thank
my
you.
time is up.
Good afternoon, Your Honors, and may it please the Court, Connor Burns for the people. The SOAR Court properly adjudicated defendant a risk level 3 sex offender and also correctly denied his request for a downward departure.
Well, counsel, what about this fact that he remained in prison longer than he needed to complete the program or get treatment? Is that exceptional?
It's certainly commendable that, again, that people recognize that he engaged in this treatment, but I wouldn't argue or I wouldn't say that either he got this treatment in prison or outside of prison. I don't think the location of where the treatment was received would affect whether or not his participation was exceptional. I think the records reflect that it wasn't exceptional, and defendant, they submitted in their Exhibit F at the SOAR hearing, his participation in the treatment was labeled as simply satisfactory, which is seemingly no more than what would be required to successfully complete the program, and it's certainly not exceptional. And it was also recommended that he receive additional treatment after being released from prison, and at the time of the SOAR hearing, he just simply wasn't engaging in that treatment. I know it was only 5 months since his release from prison, but just the facts at the time of the SOAR hearing, he wasn't engaged in any treatment.
Counsel, I have a question. Counsel mentioned that it should be a mitigating factor the defendant committed these acts when he was very drunk. Is there anything in the record to show that he's now sober?
Well, he certainly maintained his sobriety. At least he engaged in substance abuse treatment while he was incarcerated. That's certainly true, but that's certainly not a indicator of sobriety while in prison, and this court has held that in numerous cases. Sobriety while in prison is certainly not an indicator of how someone will behave when they are released from prison. And Justice Hayes at the SOAR hearing, he was cognizant of that fact. He felt it was just simply too soon, again, only 5 months after he was released from prison, to determine whether or not his sobriety will maintain after he was released. With these new stressors, I know he was taking care of his mother at the time he was released, so Justice Hayes was cognizant of that fact, and the people certainly hope that his sobriety does maintain, but again, the facts at the time of the SOAR hearing, we just weren't sure whether or not that would, what bearing that would have on his risk of recidivism.
And for a mitigating factor, you're supposed to look at factors of a kind or to a degree that weren't adequately taken into consideration of the time. These are factors that in the right circumstance, perhaps, but do we have the degree that they wouldn't have been taken into consideration to the proper degree here?
The people feel no, and certainly that they were certainly all taken into account either adequately by the RAI or just simply outweighed by the severity of his crime. I mean, as Your Honors touched upon, it was certainly a heinous act. I mean, the defendant engaged in.
In other words, just having a factor doesn't mean that it's of a kind, to a degree, not adequately taken into consideration. It really is, as one of my colleagues asked the question, was it exceptional? It really has to be to an exceptional extent.
Certainly not just listing a factor would entitle someone to a downward departure, and this court has held that it's a rare occurrence for this court to grant a downward departure, and that was in People v. Williams, and this is just certainly not the case here, where it's a rare case that this defendant would be deserving a downward departure at this time on the facts present at the time of the SOAR hearing, again, because of the mitigating factors were already taken into account, and again, because of the severity of the crime. The defendant here, he engaged in oral sexual conduct with a 3-year-old child, and that's just certainly a very severe act and one that if he were to reoffend, the harm that he would cause would be so great. And again, it all just certainly is outweighed, the mitigating factors are outweighed by either the severity of the crime and then also because the mitigating factors were already considered. And if there are no further questions, we simply ask that, we argue that the SOAR court was correct in denying the downward departure and that this court not disturb that on appeal. Thank you.
Thank you.
Your Honors, another point that we just hadn't gotten to before, I want to emphasize again, 110 points, it's the exact line. 15 of those points came from lack of supervision, which we're not arguing that those points were correctly assessed, but this court has says that, you know, exceptional, unusual circumstances surrounding lack of supervision can be a factor for downward departure. Here, you know, again, we're going back to that choice. The reason he didn't have supervision was he chose not to pursue parole. I think that is a very exceptional and unusual circumstances surrounding that factor. And those 15 points alone would be putting you at a level 2. And also, I'd like to emphasize how many of the points here are all kind of bound up. His criminal history, his use of drugs and alcohol, all of those points, again, are bound up in this addiction that his response to treatment had addressed. So given the totality of the circumstances and his commitment to rehabilitation, Mr. Roman demonstrated that he was not at a high risk of reoffense, which is why we're asking you a downward departure to a level 1 or to a level 2.
Thank you.
Yeah.
Thank you both. Scott versus Lyceum Theater.
Good afternoon. My name is Evie Kazansky. I'm from the law office of Eric Feldman. I represent the Schubert organization and Lyceum Theater in this action. I'm just going to refer to them as the Schubert organization. The lower court incorrectly denied our summary judgment with respect to the common law negligence claims, to the extent that they said there's questions of fact as to whether or not the configuration at issue was in an unsafe condition.
So, counsel, there was this circular staircase here, and at a point where it turned, there were no handrails on either side, and the handrails that existed in areas were lower than should have been there. And this was something that pre-existed standard. It existed before any pre-existing standards. It didn't comply, I'm sorry, with any pre-existing standards. So what about this circumstance? Is there no, where's the question here?
Respectfully, this situation is, the staircase is a access staircase to only the production companies. It's 100 years old. It was built prior to any of what I presume people are looking at when they look at winders and what you call twisting stairs. They're actually called winders. Because the statutory code violations don't exist anymore, the winders in and of themselves can exist. The question becomes also with respect to the handrail, there is definitely, as you can see, there is a handrail. The issue...
But this plaintiff did testify that when she was in this, she was holding onto the handrail, I think, with her left hand as she was going down the stairs. And she was carrying the laundry in a basket under her right arm. And because the part of the winder stair she got to was very, very narrow, her foot slipped and she tried to grab onto a handrail, but there was no handrail at that point. She indicated that had there been a handrail, she would have used it and she was trying to grasp for it. So why, even though I know that we're not saying that there's a code violation because there isn't, why isn't that still a question of fact as to whether there was negligence under these circumstances?
Understood. First of all, I believe that the testimony is being misread. The testimony is actually that she was on the last step before the winders began and she fell backwards. So she's not reaching out. Her hand is still on the handrail. And she said she was about to make the turn. The secondary issue is so that.
But when someone falls, as happened in this case, when they're falling, the hands usually come off of the handrail and then they grab on for something, or if they're holding, the body moves. And she's saying that when she went to grab, there was no handrail.
I understand what is being presented, but when you read her testimony, her foot began to slip on the first step before the winders began, and she fell backwards. So my understanding, she's putting that in an affidavit. That's not her deposition testimony. And with respect to the handrail.
Well, counsel, the interpretation that maybe we have and maybe that you're putting forth, why isn't that in of itself just a question of fact? And then my second question to you would be the expert affidavit. Was there any deficiency in there where he didn't opine on the reasonably safe condition of the staircase?
With respect to the expert, if I may, Your Honor?
Yes.
Okay. The issue of that you need the actual statement, the staircase is in a reasonably safe condition. The entirety of the expert affidavit said there's no code violations, the stairs themselves were in good condition, there was no transient condition, they're allowed to be in that condition, there's no prior accidents. This is a staircase that has existed in this theater for 100 years. She had used this staircase for several months before the accident. So to the extent that you are looking for these trigger words, I leave that to the court. There's nothing in the case law that says those words in and of themselves must be used for the court to say the staircase is a reasonably safe condition. And lastly, with respect to the whole issue of notice, as I just said, this staircase has been there. She was using it. Other people were using it. It's not open to the public. It's allowed. And the fact is, there's no breach. That's really the issue here. What breach did the Schubert organization and Lyceum have with respect to that theater until her fall? None. There was nothing to give them any notice that these particular winders and this particular configuration would be deemed dangerous. And therefore, we should say to you that the court was wrong with respect to the common law negligence claims. And again, we rest on our brief with respect to the contractual indemnification claims.
Thank you.
Thank you.
You get extra time for that.
And we still have George. Good afternoon, Your Honors. George Friedman for respondent. Look, this is not a case of first impression. It's typically for a jury to decide whether something's dangerous and whether there's proximate cause. There's no reason why this case is some kind of outlier, especially when you have Carter v. State and a short, Katz v. Blank, Rome, Timmons v. Benjamin. They all dealt with essentially the same exact fact pattern. How do we really distinguish our case from those? The defendants don't do it, and I think that a lot of your questions really hit the nail on the head here. I mean, just to reiterate, let's say there were no reported accidents for however long this staircase existed. Court of Appeals has held that's one factor that does not get you summary judgment. And as to notice, I think there's some confusion here between actual notice and constructive. If there are no complaints, no accidents, okay, maybe no actual notice. But constructive notice, all you need for that is that the condition was there and it was visible for long enough for them to have done something about it. There is zero question that they had that opportunity here.
Counsel, the expert affidavit that was submitted by the defendants, does it need to use that exact language, not in a reasonably safe or in a reasonably safe condition, or can it, how can we view counsel's arguments on that?
I might agree to the extent that I don't know if there are specific magic words that he would have to use, but I think when the full extent of the expert affidavit is saying there were no code violations, then it falls short. He could have easily said, given that he inspected the staircase, based on my measurements, my observations, that this was either reasonably safe or it was built according to whatever standard, engineering standard, was in effect at the time. He didn't even address it, but to be honest, I think that there's an issue of fact here with or without the expert affidavits. If you looked at the Ennis Short decision, it's in a footnote, but they say the same exact thing where you could rely just on the testimony and the photographs And a jury could say, vanishing treads, no handrail exactly where someone needs it the most, this looks hazardous to me, and then it's up to them to decide whether the condition was actionable or whether there's notice.
And in this case, you did have an expert that also inspected the stairs very shortly after the accident, I believe, and came out with a different result, and he found that the handrails were not.
Right. Well, actually, it's interesting because on that issue with the handrails, both experts actually agreed. Their own experts said, too, once you reach these winders, there's a break in the handrail. There's this post, which I think there's an argument for the first time in their reply brief that, well, plaintiff should have just held on to the post if there's no handrail.
I think what counsel was saying was, okay, that's not disputed, but the plaintiff didn't need it because she fell backwards. She was holding on, she fell backwards.
I think this whole, I'll try to be brief here, this whole falling backwards argument itself is backwards, right? The whole point is that there should have been a handrail along the entire set of stairs, and that way, regardless of which way she slipped, she wouldn't have fallen forwards or backwards. It's the same reason plaintiff argued that there should have been a handrail on the other side of the stairs, just like we had in Ennis. Of course, he's going to gravitate towards the more dangerous part of the stairs when that's where the one handrail is. So this, at worst, goes to comparative negligence, and, you know, we'll let a jury decide it.
Thank you.
Thank you, Your Honors.
I just want to
Counsel,
say,
I'm sure you're going to say your case is not backwards, so.
no. For every good case that they have, I have a good case. So forgetting the case law for a second, we're talking about these staircases and this facts. The defining issue of this case with respect to the constructive notice is, if you have a staircase for 100 years that has no transient conditions, has, you know, treads on it and everything, the dangerous issue is you're talking about around the winder. So I implore you to read her deposition, not that you haven't read it carefully, with respect to where she was and how she was walking down the steps. These stairs have been used, again, for 100 years without. So to say that there's constructive notice of a dangerous condition is, again, the same thing as using it's not reasonably safe. It is reasonably safe. Those are trigger words. The idea of a dangerousness here really goes to these staircases were being used without any violations, any other complaints or issues. And therefore, very briefly, this issue of the second handrail, it was never required. So to even suggest that the plaintiff should be allowed to suggest to a jury that a second handrail should have been there, we also request that you look at that and possibly change the ruling of the court with respect to the fact that there's not even a need for a second handrail, and that shouldn't even be allowed to be presented to a jury because that would be pure speculation.
Thank you.
Thank you.
Thank you both. People versus Jimmy Frazier.
Good afternoon. May it please the court, Svetlana Kornfein for Mr. Frazier, Jimmy Frazier, the appellant. The police arrested Mr. Frazier without probable cause. Because the arrest was illegal, the physical property, the
Counsel,
ID...
Didn't they wait, I mean, just on that issue that you've just stated, didn't they wait until they saw the defendant try to stop, put his foot in front of the door to the subway and then put his hand on the rail before they actually...
No, Your Honor, the key fact here is that when the police, when the train came into the station, Mr. Frazier went down, and then at the same time, the three officers went down also. One of them went to the conductor and told the conductor to hold the train. So after the train stopped, it was being held by the police.
Right, but that was Police Officer Gonzalez who testified that
Yes.
that's what he did. And then the next time he saw Mr. Frazier, he was already in handcuffs. So how, the observations of the other officers, Jasmine and the other officer who was with him, why doesn't that establish the probable cause, outside of the fact of what Gonzalez was doing, because he never communicated with the other officers?
Well, because they were a team, and so when he went to hold the train, he didn't just do it on his own. I mean, they held the train so that because they knew that they were going to arrest him, and Mr. Frazier,
They held the train because they knew they were going to arrest him. They had no idea what his reaction would be once they held the train. The defendant didn't know they held the train. The defendant did what he presumably always does, or whatever he decided to do at that time, he did.
right, but
So-
he didn't do anything that was arrestable. He
Well,
stepped
they
into
say
a
that,
car.
pursuant to the code, one cannot block, I know people do it all the time, that's not the issue. The question is whether it's something that one can be arrested for. He put his foot in front of the train door so that it couldn't close, and because that was a violation, they proceeded with the arrest.
Right, but the train door, he would know, he was arrested for impeding the progress of a train. He didn't impede any train because it wasn't going anywhere, it was being held by the police. So this was a pretextual arrest because they wanted to arrest him for the larcenies.
So why did he put his foot in front of the door? Why did he put his foot at the door and hold the doors?
He went into the
with his
train,
hand?
he stepped out, and then he went to the end of the car, and then
My
he
question
stepped
is
in.
specifically with his action of putting his foot in front of the door to the train and putting his hand up on that section. What was the purpose
steady him.
of doing that?
To steady himself as he entered the train.
To steady himself as he entered the train. He had walked out of the train freely just before, but he needed to steady himself by putting his foot at the edge of the car door.
But that's behavior that's consistent with innocence and guilt, and that type of behavior cannot support probable cause. That's De Boer that says that there was nothing inherently criminal, especially since the train wasn't going anywhere, and they arrested him for impeding the progress of the train. They didn't arrest him for holding the doors.
Is it your claim that if he put his foot on the door, that wasn't evidence of his committing an infraction unless the train was attempting to leave and he was preventing it from doing so?
Because the section that he was arrested for, 21 New York CRR 1056A, prohibits any act which tends to interfere with the provision of transit service or safe operation of the conveyances of the transit authority. The train was not moving. It wasn't, he did not impede anything from moving. So this was a purely pretextual stop. They held the train because they knew they wanted to arrest him. And so his briefly touching the doors, and when Jasmine testified, he said he was holding the doors. So they didn't talk about his foot being in the door. They arrested him for holding the doors.
Well, holding the door, the purpose of the foot was to hold the door. He had the foot in the door, and he was holding it.
Well, no,
But
but
one
they were
officer,
talking about
back
his
to the other issue, one officer didn't know what the other officer was doing. So those officers stopped him because they saw him impeding the progress of the train. They saw him put his foot there.
Right, but you
They
don't-
weren't the ones who went to the conductor. Isn't that right?
Well, Your Honor, you're assuming that they didn't know that he went.
So are you. You're assuming they knew.
Well,
I'm not assuming anything. There's no evidence in the record that anybody told them that. The only evidence is that the other officer went and spoke to the conductor. That's what we know. So from that,
But it's a reasonable inference because they were a team, and they were a transit team, and Gonzalez testified.
but he doesn't
that-
testify to that.
Well, he testified to, he said, so he won't close the doors. I've had a lot of experience working in transit and the subway, so that the conductors, they close the door regardless of whoever is getting on and off the train. So it's a standard procedure that the transit police have, that if they want to talk to someone who's in the train or pull someone out of the train, as they did with Mr. Frazier, they're not going to take the chance that the train will continue. So I think that it's.
Are you asking us to impute Officer Gonzalez's decision to ask that they stop the train to the other two officers?
Absolutely.
And if so, but what is your basis for asking us to impute that?
Well, it's the type of information that can and should be imputed because they were acting as a team. They weren't, he wasn't acting on his own. They were there to arrest Mr. Frazier. It was a special Saturday operation to get Mr. Frazier for the larcenies because he was suspected in the pattern larcenies. He didn't do anything arrestable in the station. And so when they saw him, start to go in the train, then hold the door briefly, then go out, and then go down to the other end, and he went in. And at the time he went in, he didn't know that the train was being held by the police. That's the truth. But he was arrested for impeding the progress of the train. He was not the agent responsible for the train not moving. The police impeded the progress of all those people sitting on the train. And
Thank you.
Okay.
You have some rebuttal.
Good afternoon, Your Honors, and may it please the court, Max Bernstein for the people.
Counsel, let's just start where your adversary left off. In terms of the sequence of events that led to Mr. Frazier's arrest, so we know, based upon the record, that there was a wealth of information that Mr. Frazier was probably a suspect in these larcenies, right? So they get to the train station and they observe him, and then there's this infraction that occurs, which normally people wouldn't be arrested for. People hold the trains all the time. Why should we credit the police officer's testimony, or why should the court have credited the police officer's testimony and not found that that was pretextual?
Well, Judge, I think before this court are multiple options. The court below found that the stop was constitutional not only on the basis of the transit infraction, but also because once an ID was handed over at the De Boer level 1 stop when he was asked to step off the train, there was then probable cause to make an arrest for the larcenies. So you can elide the entire transit stop issue if you'd like, but in the particular instance here, it is certainly the case, I believe Sergeant Jasmine testified to this, that in the normal course of transit officers' work, they would not typically have stopped someone or arrested someone for this violation. But as they mentioned in their testimony, there are aggravating factors that come up in the course of transit officers' work that might warrant making that stop where they otherwise wouldn't. And I think, so the officers are basically saying that in general, they exercise restraint not to do this unless there's some good aggravating reason to make a stop for a transit infraction like this. And I think the reasons here are pretty plain. All of the information they had that made Mr. Frazier a suspect, coupled with the fact that he was in fact doing behavior that to all of the officers present seemed like casing behavior, all of that complete constellation created a basis for making a stop that they might otherwise have let slide under different circumstances. And I think it's hard to say just how long this blocking of the doors was going to take place, because Mr. Frazier was actually stopped with his hand on the subway door in the midst of blocking it by the police, and it's purely speculative how much longer he was planning on doing that. So,
and this train, though, Officer Gonzalez did testify that he went to the conductor and told him not to move the train. How significant is that particular fact in terms of what Officers Jasmine and the other officers' names escapes me right now, what they were doing when they were arresting Mr. Frazier?
I would say not, for two real reasons. First of all, as was discussed, I think the record makes it ambiguous whether or not the train was in fact stopped at the time that Mr. Frazier actually did block the door. But secondly, if you actually look at the text of the transit infraction itself, and this came up in the brief, the offense is not only interferes with the provision of transit service, it's also any action which may tend to interfere with the action with transit service. So you might think of a circumstance in which someone blocked a train door for an extended period of time without knowing that, in fact, there were signal problems on the subway and the train was not actually going to move at that particular moment. That doesn't make the conduct not a violation of Section 1050 because of the unknown fact that the train was already going to be stopped for some unrelated reason. Any activity which tends to interfere with subway service is a violation of the transit.
So if he stopped, if he put his foot in the train, which at a time when the conductor was not trying to move the train, are you claiming that that's still a violation of the rule requiring, barring anyone from impeding the progress of a train, even if the train wasn't in the process?
Again, Your Honor, not from impeding the progress from the train, but from taking action. This is the text of the statute, from taking action which may tend to impede the progress of the train. So, yes, under the black letter of the law, blocking the door might tend to impede the progress, even if in fact at that moment it wasn't.
So is it your claim that they're that they stopped him, that they had a basis for stopping him because he committed this infraction, that they then asked for his ID, which then tied him to the information they had about the larcenies, and that then created the de Boer standard?
I would frame it slightly differently, Judge. I would say that the stop itself, I would put the transit infraction totally one side for a second and say the stop itself was a de Boer level 1 inquiry based on a variety of objective, credible reasons to stop him at that particular moment, and then a request for ID falls under the de Boer level 1 standard, and then at that point they had probable cause to arrest him for the larcenies. So you don't need to call upon the transit infraction at all. I think there's more than enough for a de Boer level 1 stop, which was taking him off the train and asking for ID, and then once the ID was on the basis of the larcenies and the casing at that day. And then at that point, they had probable cause to make an arrest for the larcenies. So I don't think the transit stop itself needs to be dispositive in this case one way or the other. So, thank you.
Okay, with regard to the probable cause for the larcenies, I discussed that in my reply brief, and I refer you to that. What I do want to say is, in terms of the ID, Sergeant Jasmine, the day before they set up this Saturday operation, received from his lieutenant, Lieutenant Morris, who received from Detective Vargas, the transit recidivist report. It's on page 85 of the January 5th transcript. On 85, it's Exhibit 1B, it's the transit recidivist report that Sergeant Jasmine had before they even went there on Saturday. So they, and with his camera, he took a snapshot of that photo, and then he shared that with the other 2 members of his team. So when they...
I'd like to interrupt you for a second. I just want to make sure I understand your argument. Is it your position that once they saw defendant sort of case acting unusually in the subway station, would you agree that that was sufficient for a de Boer level 1 stop that would justify their asking him questions and asking for his ID?
Yes, it was sufficient for de Boer level 1, but they already knew his ID.
Excuse me, once they then got his ID and saw that it was the same name as their investigation had connected to the string of subway larcenies, why wasn't that sufficient to lead to provide probable cause for an arrest?
Because how could it go from a level 1 to a level 4 when he hadn't done anything? He was just walking around in the subway. And again, this is behavior that is consistent equally with guilt and innocence, and de Boer and the Court of Appeals in Carrasquillo, they say that such behavior cannot support probable cause. So assuming that he had level 1, you know, they saw him walking around. But the level 1 led to their asking for his ID, and his ID is what tied him to the string. But they already knew that because they were there with his photo, his name. They knew everything. They were watching him. How would that go to level 4 from a level 1? When he gave them information, he just confirmed what they already knew. But there was no criminality that escalated it from a level 1 to a level 4. They knew they had that transit recidivist report. So when they said they took him up to the mezzanine where they ran that can't be true because they had it going in, and Sergeant Jasmine testified to that. That's where he got the photograph, that they had the photo. They knew everything about him. They were watching him in the subway to see if he would, as Sergeant Jasmine testified, he was a possible suspect in the larcenies. We were there to prevent a crime or to stop a crime in progress. They didn't see that. That's why they had to resort to that pretextual stop with the trains, because they didn't want to lose him when he got into the car. He was already in the car when Jasmine told him to come out, and that's when they asked him for the ID and they handcuffed him.
Thank you. Thank you. Thank you both. Rodriguez versus Quick Realty.
Good afternoon, Presiding Justice Renwick, members of the court. My name is Michael Kelton. I handle this case from inception through the motions below. It is the plaintiff appellant's position that this case should be decided in the very same way that this court, with Justice Renwick presiding at that time, decided in the case of Hill against Manhattan North Management. That's a 2018 case, the most recent case we could find from this court on the issue of a tenant slipping and falling on water in the vestibule of her apartment building. In that case, the plaintiff slipped and fell on water in the vestibule. The defendant moved for summary judgment, alleging lack of either actual or constructive notice, as the defendant has in this case. Justice Jaffe below denied that motion for summary judgment. It came up to this court. This court unanimously affirmed the denial of that motion for summary judgment. In doing so, this court found that it is the movant, the defendant, who has the burden to prove that it lacked either actual or constructive notice. And the court said that it was incumbent upon the defendant to aver or testify as to a janitorial schedule on the day of the accident, or when the area was last inspected prior to the plaintiff's fall.
So let me ask, so was there sufficient notice for constructive notice? I mean, it was.
There was, but again, it is.
And what were the factors for constructive notice?
The superintendent testified, not testified, told the managing agent, and the managing agent testified to this in his deposition. The superintendent told him it was raining, I was mopping the floor, and I just couldn't keep mopping the floor.
And he put a mat down.
So I put out, he said, a caution sign and the mat in question.
Yes, and the caution sign was removed by someone, the mat remained.
That is the defendant's contention. We don't accept that. That is a question of fact.
Did your client testify that she saw any caution sign? Or did she say yes, no, or either? I don't remember.
There was, I believe the testimony was there was no caution sign at the time of her fall.
Okay.
The superintendent said someone removed it at some time when they were moving furniture in the building. Now, that's a question of fact. It just so happens the plaintiff does not agree that there was ever a caution sign put there. But that's the superintendent's position.
Okay.
Sir, ultimately, this distills to whether or not there's a tribal issue of fact with respect to notice, right?
Absolutely.
And so what was the infirmity in the move-in's proof on that subject?
On the move-in's proof, it was incumbent upon them to come forward with, as this court held in the Hill case in 2018, it was incumbent upon the move-in to come forward with evidence of a janitorial schedule on the day of the accident or when the area was last inspected. By the way, this court also held in another case, the Ruiz case from 2020, more recent actually than the Hill case. It is incumbent upon the move-in to offer specific evidence as to their activities on the day of the accident, including evidence indicating the last time the area in question was inspected, cleaned, or maintained before the fall. That's the move-in's burden on a motion for summary judgment. They didn't do it in the Ruiz case, they didn't do it in the Hill case, and they haven't done it in this case.
Now, there was a mat there, but there was testimony from the defendants themselves that the mat wasn't as long as it could have been. That was a little short. Maybe it would have been a better idea to have a longer mat because we know that it's not incumbent upon the defendant to cover the entire floor with a mat, even if it's slippery, but that this particular mat did not cover the area that needed to be transversed from one door to another.
Exactly, Your Honor. We're not saying the entire vestibule floor should have been covered, but there is a pathway from the outer entry door to the inner vestibule door. And there are certainly mats that could cover that walkway. This mat covered maybe a little more than half of that walkway.
It seemed that
a good 10 feet
she
uncovered.
fell after she got off, I mean, at least from the pictures, it looked like that's where she was
Just
falling.
as she stepped off the end of that short mat. Correct.
Thank you.
Thank you very much.
Good afternoon. May it please the court. And my name is Kim Jansen. I'm here today on behalf of the defendants. I thank you for your indulgence in allowing me to argue pro hoc vice today. The summary judgment motion in this case was ultimately decided based on plaintiff's own admissions. For there to be constructive notice, you have to have a visible and apparent defect. Plaintiff herself conceded that she never saw water on the floor before she fell. She said,
but she saw it after she fell, and her husband took a photo of it about 10 minutes afterwards. She
and
saw
nobody
it.
can see.
Most people slip and fall and then find that they're wet and then realize there's water on the floor. That's how it happens. Otherwise, they avoid the water. So.
Right. So first of all, we don't know that the water was wet before she fell. She testified that she came in from the street, had to walk through some snow to get there. So the water that she found on the floor after she fell could easily have come from her own boots. But for purposes of constructive notice, what's important is that whether there's...
So sorry. So you're saying she walked on the mat that was put there to presumably absorb the water and everything else. So, but you're saying that she came in, walked on that, and then after walking on the mat, wiping her feet or not, then the water was still on her boots, which means that the mat wasn't adequate. Is that what you're saying?
It's possible that the mat wasn't adequate, or that it didn't completely dry her shoes. What's important in terms of constructive notice is whether there was a visible and apparent defect. And if she didn't see it, her husband didn't see it before she fell, her son, after he came down, could not recall having seen any water. She testified that when looking at those pictures that her husband took right after the fall, well, you can't see any water in those pictures. She says, well, you can't really see it because, you know, the tiles are dark. You can't really see the water.
What about what counsel said about there's no record of when they inspected, that there was some regular inspection so that they would have found it if it was there?
So the purpose of that standard, that is certainly one way to prove the absence of constructive notice, is to present a janitorial record, observations, et cetera. But if you don't have a visible apparent defect, testimony that the janitor or a superintendent or whoever walked through and inspected and didn't see something that wasn't visible wouldn't mean much. Take, for example, the case that was argued a little earlier today with the winder stairs. If the evidence came in that, yeah, perhaps not this particular set of stairs, but that those stairs were built perfectly to code, the handrails were in all the right places, everything about the staircase was as safe as humanly possible, there'd be an absence of any defect. You wouldn't need to bring in janitorial inspection records to prove the absence of constructive notice because you're showing there's no visible apparent defect.
But in this case, we're talking about a transient condition, whereas in the case you're referring to, that was more of a permanent structural type alleged defect.
And it's important to note that this occurred at 1 a.m. in the morning, and there are a plethora of cases saying that, it's not a property owner's, a building manager's responsibility to continuously monitor and mop up tracked in water, tracked in snow. There's a limit. Eventually, the superintendent needs to go to bed. We know that when she left at 6:30 p.m., she testifies that there was no water in the vestibule. It was dry. When she comes back at 1 a.m. and she falls, we don't know when that water may have gotten there. We don't know how it got there. Presumably tracked in snow, whether from her own shoes or someone else's. But it's not the property manager's responsibility to stay up all night and, not knowing when people are going to be coming and going. This isn't the peak rush that people are coming and going from their apartments.
Thank you.
Thank you.
Thank you both. Center versus BLDG, Oceanside.
Good afternoon, Your Honors.
Good afternoon.
On behalf of the respondents, just since I only have a few seconds, I wanted to just point out two misstatements that the plaintiff makes that permeate his main brief and his reply brief, which are important. One is that the plaintiff gives the impression that 10 pipes weighing 50 pounds fell on him. However, the plaintiff testified at his deposition.
I didn't get the impression that anything fell on him. I got the impression that one pipe hit him, or a pipe hit him in the head.
Thank you. Perfect. The next, yes, correct. Okay. One pipe came into contact with him, not more than one. Additionally, there was evidence from the defendant's superintendent that the pipes were as short as 6 feet and weighed as little as 10 feet, which the plaintiff also...
Weighed as little as 10 pounds, you meant?
I apologize, yes. So you could have here an instance of a 6-foot pipe that weighed as little as 10 pounds, falling some unknown distance or traveling some unknown distance before it came into contact with the plaintiff, since there is no evidence in the record how far it moved before it contacted the plaintiff. And for that reason, the plaintiff did not prove that there was more than a de minimis fall or a falling object. In addition to that, the plaintiff also indicates that the cart was elevated 3 to 4 feet. That's not correct. There's no evidence how big the wheels were or how high above the ground the bottom of the cart was. And the photographs, or the photograph of the cart at record 324 shows that it was a small wheel at the bottom of the cart, so it was not elevated 3 to 4 feet. The lower court's order should also be affirmed because in opposition, defendants submitted multiple affidavits that clearly raised the question of fact as to whether or not the plaintiff was a sole proximate cause of his accident by overloading that small cart with 10 to 11 pipes. We submitted the affidavit of the very superintendent who the plaintiff claimed told him to put the pipes into the cart, who supposedly rushed him, who supposedly said you can't carry them by hand, and the superintendent refuted each and every one of those assertions, indicating that they're not true.
Thank you.
Thank you for the time.
People versus, I'm sorry, PJSC National versus Piragova.
Good afternoon, Your Honors. Victor A. Worms for the appellant, Natalia Piragova. Judge, with your indulgence, can I make reference to my iPad if I need?
Yes.
Thank you. Your Honor, while this may be a complicated case, it really comes down to an evidentiary matter, Judge. This action was commenced as a summary judgment in lieu of complaint, to recognize 3 supposed Russian judgments. Now, there are issues of Russian law, which I'll discuss briefly, but at the core of this case, Judge, is whether or not the plaintiff respondent has satisfied their burden of proof on a motion for summary judgment. It is really that direct, Your Honor. Once you commence a proceeding as a summary judgment in lieu of complaint, all the rules of summary judgment applies. Summary judgment is the functional equivalent of a trial. Therefore,
There's only, we are only determining here the ministerial function, right? Just to recognize the foreign country's judgment and determine whether or not that was final and conclusive and enforceable here.
that is true, Judge, but here is the issue. The issue is, in order to determine that, you have to look at two things, Judge. The law of the country that's at issue here, which is Russia, and the evidentiary support that was offered by the appellant, by the respondent, to indicate that the judgment was final and enforceable. And that's where the problem arises, Judge. We have two separate issues which I can sort of decouple so the court can appreciate the issue. On the one hand, there is the issue of law. The question is whether or not, under Russian law, there's a 3-year limitation period by which you must file the writ of execution. Otherwise, it is barred.
And you feel that an expert was necessary to...
In fact, we produced an expert which indicated that there is a 3-year limitation on the filing of the writ of execution, and that once that period has expired, you cannot refile it. It lapses. So there is no basis on which it can be enforceable. So that's the one issue which deals with the law. But then there's a separate issue which deals with the evidentiary support. They offered to prove that the writ of execution was filed or commenced, no document that would be admissible under New York law. CPLR 4552 provides that you must have an apostille to foreign documents. Every single document that they've offered in this case, Judge, lacks an apostille. None of these documents are admissible. In actual fact, if you take a look at the record, and I can go through the numbers with you, I don't need to do that, they're photographs with cell phone. They have court documents that they take pictures with a cell phone. You can see the table, you can see the person taking the photograph. So they've come into this court, to the New York court, to seek to recognize 3 Russian judgments in which they haven't produced a single evidentiary support that would allow, on a motion for summary judgment, any court to admit any of these documents. So the issue really is twofold. The law in Russia that says that because they failed to submit the writ of execution within the 3-year limitation, they're barred, which does make it unenforceable. And
Counsel, didn't the plaintiff also bring in an expert in Russian law to deal with some of these issues you're raising, and the judge had an opportunity to review both experts and made this determination that, unlike what your experts said, they were able to refile these documents after the 3-year?
There were 2 experts, Judge, and they both...
Each side had an expert.
Each had an expert. The judge never addressed the issue of the expert. What it did do was to rely upon its prior decision in Bat by...
Yes, he was, I mean, that case was very similar, and that got affirmed by us. So yes, there was a lot of reference to that I saw in the...
Right. But that case, Judge, was materially different factually than this case that would not provide presidential support for that determination.
And how specifically? That was going to be my next question.
Yes, Judge, I can highlight the 3 points. In the Bat Brothers case, they said it wasn't final and enforceable because they were contemplating appeals, that they needed to have the approval of the Russian bankruptcy administrator, and they thirdly argued, Your Honor, that there was a lack of standing because the consideration that resulted in the assignment of the judgment was not proper. We have made no such arguments, Your Honor. We haven't said that it's not final because there's a pending appeal, because we've never argued that. What we have said, and what distinguishes our case from the Bat Brothers case, is that in this particular instance, regardless of what you may look at the Russian law, at a core, the idea that someone could come into a New York court and seek to have a judgment recognized with not a single document as an apostille. It's not something that you could do at a trial. And here we have not a single document that is authenticated.
But what the thing is, didn't didn't plaintiff argue and didn't the court agree that while they might not be enforceable at this moment, because I believe that there is bankruptcy proceedings to complicate all this, that they, that maybe execution it would be stayed at this point, but they're ultimately enforceable. Wasn't that distinction drawn during the arguments a lot?
That was a distinction was attempted to draw, but it is undisputed that these judgments are enforceable by their own experts. They said this only within the bankruptcy court. And by New York law, when you have a judgment that is enforceable, it has to be separate from any other proceeding. In other words, it has to be enforceable immediately. And when I say immediate, I don't mean right this moment. What I mean, no further court proceeding is required. And here, it is undisputed by their own expert that these judgments can only be enforced within the context of the bankruptcy court. So it's not enforceable.
Thank you.
May it please the court, good afternoon, Your Honors. Charles Nurko of Barclay Damon for Plaintiff Respondent Trust Bank.
Counsel, could you address what seems to me was the primary issue raised by your colleague, that your summary judgment motion in lieu of complaint didn't include any documents sufficient to satisfy the standards for documents to be admissible for summary judgment?
Yes, Your Honor. So with respect to the apostille, CPLR 4542 says that foreign documents may be evidenced by an apostille. That CPLR provision is permissive, not mandatory. It does not prevent the bank from introducing foreign court records through other foundations, such as the Sokolov affirmation and the Stepchenko affirmation, where each affiant testified to their personal knowledge of the foreign court records, as well as their incorporation of those records into the bank's own business records.
So your view is that you authenticated them by means of that testimony rather than by an apostille?
Correct, Your Honor.
And counsel, could you, because I'll forget it probably, address what effect, if any, on this case there is from the Southern District decision, which went against you? How did that affect anything in terms of the enforceability or the ability for you to get summary judgment in this case?
Yes, Your Honor. So the Southern District case was a Chapter 15 case. That's a case to recognize a Russian bankruptcy. The bank was not the foreign representative that was litigating that. So that was the bankruptcy foreign representative who went to the bankruptcy.
The trustee in bankruptcy.
Right, the trustee. And based upon Piragova's opposition, the bankruptcy court refused to recognize the Russian bankruptcy proceedings. If there was recognition, the U.S. bankruptcy court would marshal Piragova's assets for distribution in Russia. Because that did not happen, and this is similar to Bat Brothers, the foreign judgment creditors can then come into the United States and directly execute on U.S. assets in accordance with New York state law.
And how does this pending bankruptcy proceeding affect the enforceability of this judgment that you're trying to, get summary judgment on in this case?
So under the Bat Brothers framework, Your Honor, the enforceability is not affected. As Mr. Sokolov testified in his affirmation, the judgment's enforceable in Russia during bankruptcy proceedings, within the bankruptcy case, and after the bankruptcy. The judgment remains enforceable unless and until Piragova establishes her entitlement to a discharge. Justice Borak explained in the proceedings below the difference between enforceability and execution. And if we could just take a moment, I think a good example is helpful, where if our court system renders a judgment against a New York judgment debtor who only has two assets, one is Social Security income exempt from execution, and two is a foreign bank account. Even though execution can't proceed in New York under our rules, we would hope that a foreign country recognize the New York judgment and allow that foreign bank account to be executed on, even though from the perspective of that foreign court, execution is suspended and not occurring in the issuing state. And it's the same thing that's happening here. Execution is suspended in Russia, but the judgment remains enforceable, and execution can continue with respect to assets not included in the bankruptcy estate.
And defendant raised in his papers the fact that this case should, the ability to get summary judgment should be affected by the sanctions on Russian banks and whatever that have been in place since the beginning of the Ukrainian war. What do you have to say to that? How does that affect this case?
It does not, Your Honor. This was waived by not being raised below. The simple answer is to look at the...
I'm not sure the war had started then when it was...
Well, sir, I'm happy to address it on the merits, Your Honor. If Your Honors look at the U.S. Treasury's OFAC sanction list, you can go to the government website, type in my client's name. It's not there. If you look at my client's ownership structure, sanctions don't apply based upon the shareholders that own my client. So Piragova alleges that Akriti Bank, which is sanctioned, owns shares of my client. Under the sanctions regulations, Akriti Bank must own 50% or more of an entity for an Akriti subsidiary to fall under Akriti sanctions. Piragova's brief alleges that the Russian central bank owns 97.7% of Trust Bank shares, so just by simple math, Akriti Bank cannot own more than 2.3% of Trust Bank. With respect to the Russian Central Bank's ownership of Trust Bank, the OFAC directives prohibit U.S. financial institutions from purchasing bonds or lending to the Russian Central Bank. There is no directive that would bar transactions in which the Russian Central Bank has an interest.
Sir, go ahead and finish your answer if you were.
Yes, Your Honor.
Could you address the issue of the use of CPLR 5004's 9% interest rate to the Russian judgments prior to the date of their domestication here?
Yes, Your Honor, and I refer the court to page 42 of our brief. There are several First Department cases that hold that prejudgment interest, and in the context of a recognition proceeding, prejudgment interest is measured from the date of the foreign judgment to the date of the New York judgment. That accrues at the CPLR statutory rate of 9%. And I would also note, too, Trust Bank voluntarily waived 11 days of interest to reflect the time that the judgment was not able to be executed on in Russia.
That doesn't seem to come to too much, but that's very nice of you.
Thank you. Do you have anything else? Any other questions? Thank you.
Thank you, Your Honors.
Thank you, Judge. Just a few points I'd like to highlight on my rebuttal. One is his argument that he could establish the document's authenticity through affidavits. That simply is not the case, Your Honor. We have cell phone photographs. We don't know who took these photographs, when they were taken, and under what circumstances. So Mr. Sokolov didn't say he himself took the photographs. Never once does he address in his affidavit anything about the authenticity of the documents.
Your client isn't saying that the judgments don't exist. You're just saying that they weren't authenticated properly, right? Because she didn't have an affidavit or any from your client saying that these judgments weren't entered against her. You're just saying that they aren't authenticated?
Well, it's more than that, Your Honor, because if you take a look at the expert, he said that he went onto the bailiff's public website because all judgments that are enforceable in Russia gets placed in a public website. There was no documentation in the public website with any of these documents that they now claim to be attached to Mr. Sokolov's affidavit. So he says that he has great questions about the authenticity as well as whether or not there has been some fabrication. So it's a very serious thing because we have Mr. Sokolov's affidavit in which he himself cannot authenticate these documents because he himself didn't take the photographs and he himself has no idea how these documents came into existence. He merely references them in his affidavit. On the question of interest that was raised previously, it is very clear that in order to have any award of interest, the judgment itself must provide for interest, which it doesn't do. So the award of interest by the lower court was a clear error of law because you cannot do that. And of course, I made reference, and I won't take up the court's time, between the breach day and the conversion date issue. That is something, if you look at what they did, Judge, they backdated the award of judgment to July 11, I think 2016, well before the judgments were recognized. So you see on both the judgment issue, there is an issue that would require reversal.
Thank you. Thank you both. People versus Alejandro Campis. Thank you.
Good afternoon, and may it please the court. I'm Jihyun Rim with the Legal Aid Society representing appellant Mr. Alejandro Campis. Mr. Campis's post-release supervision term of 3 years is excessive and should be reduced to the minimum of 1.5 years, given the fact that he received the statutory maximum where the present offense is a nonviolent felony and where he has demonstrated great rehabilitative potential. Mr. Campis has demonstrated strong rehabilitative potential. He's capable of maintaining a job, and he worked as a barber for 3 to 4 years prior to his arrest. He's a loving father to his daughter, and who he takes care of with the help of his girlfriend. He accepted responsibility for the present offense, and he was granted early merit release. Currently, he is working and taking care of his daughter. He's been in post-release supervision for about 1.5 years at this point, and he has had no new infractions or arrests, suggesting that he has also been making meaningful progress in addressing his substance dependency issue. Mr. Campis's less is more likewise should not be used to remedy harsh or excessive sentencing. It should be used to further reduce post-release supervision from the appropriate 1.5 years that we request, especially in light of the fact that it was enacted because of the social science demonstrating the harm of long post-release supervision.
Isn't it likely that he will receive the benefit if he continues to behave in what you described as his exemplary way? Won't he receive the benefit of the Less is More Act?
Correct. The Less is More Act may have a practical benefit of shortening his post-release supervision, but it shouldn't be used to replace what we're arguing as a harsh or excessive sentence to begin with. Again, this was a nonviolent drug felony, and he received the maximum of 3 years of post-release supervision. And
He
so
negotiated that?
Excuse me, sorry?
His attorney negotiated that for him. This was a negotiated plea. It wasn't a conviction after trial, right?
Correct. This was negotiated for. Mr. Campis has been under supervision for about 1.5 years at this time, which is the time the benefits of post-release supervision starts to plateau, and he has demonstrated that he's ready to fully rejoin the community. And ultimately, while a few more months may seem modest to the rest of us, it's meaningful for Mr. Campis, who's unable to plan out the rest of his time until the end of his post-release supervision.
What was the top count that the defendant was charged with?
The top count was 1 count of criminal sale in the first degree.
Is that an A1 felony?
Yes.
And so what was his sentencing exposure for incarceration on that?
The sentencing range, Your Honor, it was 7 to 15 years, I believe, or 6 to 15 years. Just to clarify what went on, though, Mr. Campis was named in 9 counts of the 17 count joint indictment, and he was not named individually in a single count. And his co-defendant was named as the principal of this scheme, and he was the one who was eventually convicted of criminal sale in the first degree.
But he did get more time than Mr. Campis.
But they both received the same
sentenced.
amount. Exactly.
He was sentenced to a higher sentence, right?
Yes.
The other individual.
I'd also like to point out that they both received the same amount of post-release supervision.
Thank you.
Thank you, Your Honors.
May it please the court, Peter Rienzi for the people. Good afternoon, Your Honors. Defendant's negotiated sentence was fair and appropriate, but in any event, his excessive sentence claim is foreclosed by his valid waiver of appeal. The fairly negotiated plea was very favorable to the defendant, considering the facts of the case. As Your Honor pointed out, defendant was indicted for counts involving 3 separate sales of narcotics, of a large weight of narcotics. One was an A1 felony sale, and the other 2 were A2 felony sales, as well as 6 B felony counts. Defendant was allowed to plead guilty to a single B felony count. I believe, Your Honor, that is the exposure on that charge, the count that he pleaded guilty to, was the 6 to 15 years. My understanding is that it would be a maximum of 30 years in state prison on the A1 felony sale. And this is because the defendant was a second felony drug offender who had a prior violent felony conviction.
The court's discussion of the waiver adequately described the appellate rights being waived?
Thank you, Your Honor. Yes, the court did, in the discussion of the waiver of appeal, the court did describe the rights as, the appellate rights as separate and distinct. The court referenced both the plea and the waiver on several occasions during that colloquy, in other words, as 2 parts of that plea agreement. On the record, the defendant acknowledged that he understood the rights he was waiving, that he had consulted with counsel. He also conferred with counsel on the record. That's part of the plea minutes. Defendant agreed that he had no further questions. Both defendant and counsel signed that written waiver, which supplemented the court's oral colloquy, as well as...
But the court didn't specifically describe what rights were being waived and what rights were not being waived by the appeal waiver, correct?
That is correct, Your Honor, yes.
Isn't that a deficiency that we have to consider?
Your Honor, I think the court could consider it, but I think if the court reviews other cases, cases by this court, there are a number of cases where this court has held that if there were deficiencies in the oral colloquy, it was made up for in the written waiver. In this case, the written waiver did include those non-waived clauses. Those were mentioned and laid out in the written waiver, which was signed, again, by defendant and counsel. And then in addition, Your Honor, there are numerous, obviously, Court of Appeals cases that reference shorthand language, overbroad language, incomplete language, and that the waivers are ultimately enforced. If there are any further questions, I can answer them. Otherwise, I see my time is up and we would rest on our briefs.
Thank you.
I'd like to push back and discuss the appeal waiver to begin with. Mr. Campus's did not properly waive his right to appeal because the waiver cannot be considered knowing, intelligent, or voluntary because there were 3 main issues with the appeal waiver. 1, the plea court suggested a total bar to appeal and orally associated the right to appeal with the right to trial. It's very clear that the court suggests an absolute bar and then goes on to discuss Mr. Campis as giving up his right to appeal following his right to trial. Number 2, Mr. Campis's attorney did nothing to correct any misapprehensions that the court statement may have created. And although my adversary may say that this sort of corrected the shortcomings of the oral colloquy, it is ultimately the plea court's job to make sure the defendant understands his rights. And third, Mr. Campis signed the written waiver appeal before rather than after the plea court explained the nature of his right to appeal. I see that my time is up. Thank you.
Thank you both. Alvarez and Marshall Valuation Services versus Solar Eclipse Investment Fund.
Good afternoon. May it please the court. Karen Klein from Olshan Fromolowski LLP, counsel for Appellant Alvarez and Marcel Valuation Services, who I'll refer to as A&M. This action arises from the respondent's refusal to indemnify A&M pursuant to engagement letters between the parties. Critically to this appeal, those engagement letters all contain a provision stating that the parties, quote, waive any and all personal rights under the law of any jurisdiction to object on any basis, including without limitation, inconvenience, and forum, to the jurisdiction or venue within the state of New York for any litigation arising in connection with this agreement. Yet the trial court dismissed this action against 24 of the 34 respondents for lack of personal jurisdiction.
Well, isn't the real issue here whether all of these defendants should have their case heard in California where this matter is, where a virtually identical matter is already pending?
I don't agree with that, Your Honor, because with respect to 10 of the defendants, the court stayed this action pending California. We are not seeking review of that decision. We are only seeking review of the dismissal for lack of personal jurisdiction, and for the other bases, the court dismissed the action.
The defendants that were dismissed, I think there were 24, but I could be wrong, they signed an engagement letter that was that everybody was signing before November 2016, and then they changed it afterwards to change the wording it a little bit. But it seems to me that you just read part, but I don't think all of the engagement letter. And if you read that forum, you know, that jurisdiction portion, jurisdictional forum selection provision, it really talks about the federal courts, and then at the end, it talks about the state of New York. Later, they amended those engagement letters to specifically add in the state courts of New York. So if you're reading this provision, the pre-November 2016 provision, from beginning to end, isn't the correct way to read that they're talking about exclusive jurisdiction in the federal court and not in the state court, which is where you brought it?
If you're referring to the exclusive jurisdiction provision within that clause, it does refer only to the federal courts. However, the law is clear that where federal courts do not have subject matter jurisdiction, you can then proceed to any other court that has personal jurisdiction. And the last clause, which refers to waivers of objections to jurisdiction in the state of New York more broadly, as opposed to within the Southern District of New York, clearly operates as a waiver of objections to personal jurisdiction in New York. Now, that may not be part of the exclusive provision, so that means if there's no jurisdiction in federal court in the state of New York, then you proceed to any other jurisdiction that has personal jurisdiction. Based on that waiver, New York state courts are one of those jurisdictions.
Yeah, but if, okay, so assume that I agree with that analysis. So then there's already a case pending in California where the defendants are the plaintiff and the plaintiff is the defendants, right? And your client tried to get that case dismissed and it wasn't dismissed. And when you then put in an answer after the pre-answer motion to dismiss was denied, you asserted, as far as I could tell, and please correct me if I'm wrong, basically the same claims against those parties that are now in this case. How many different courts do you need to have litigating this?
Yes, Your Honor, we did assert compulsory counterclaims in the other action. However, I just want to separate these two issues, right? There's the issue of personal jurisdiction, and then there's the issue of whether to stay or dismiss on the basis of a prior pending action. Our view, if the court agrees with our interpretation, which I laid out of the forum selection provision, is that the personal jurisdiction holding was erroneous. So then turning to the prior pending action, if the trial court clearly said that if it does not dismiss for lack of personal jurisdiction, it would stay pending the California case. We're not disputing that. We're not disputing the stay. We're only disputing the dismissal. However, with respect to CPLR 3211A4, which was the dismissal based on the pending action, that requires a prior pending action with a substantial identity of the parties and the issues. At the time we filed our indemnification action here, there were no such claims pending in California. The trial court correctly held the first time we asserted those claims were in New York State court. And the issues that were pending in California at that time, there was not a substantial overlap of parties or issues.
Well, they have more parties, but everybody else is in there, aren't they?
There are many more parties in California, and the issues are much broader. However, there were no claims for indemnification that had been brought. We had not brought any claims under the engagement letters in California at the time we asserted the claims here. In fact, California, the funds who were dismissed out, the 24, the engagement letters, most of the engagement letters that I issue here are against funds versus investors. A&M entered into two engagement letters with two parties. The funds are not asserting any claims against A&M in California. They're only asserting claims against A&M in Florida. The investors are asserting claims against A&M in California. So it is actually the respondents who started here in multiple forums. And given that the engagement letters provide that they're governed by New York law and they have forum selection provisions in New York courts, we brought the action to have them determined here. However, given that the court stayed the action as to the 10 parties that were not dismissed, our position is that given that there is personal jurisdiction as to the remaining 24, those claims should be, that the dismissal should be reversed and those claims should be reinstated, but stayed along with the other 10. And if I may just briefly, I know my time is up, I just wanted one more point. The court also dismissed as to 4 of the funds claiming that A&M did not properly plead that they signed or ratified the engagement letters. That is not correct. A&M pled that those parties signed the engagement letters. That was on information and belief, but that's sufficient for purposes of motion to dismiss. But even if they did not, A&M pled that those funds accepted the reports that were the benefit of the engagement letters, and the respondents, the funds, in fact pled in the Florida litigation that they received and relied on those reports on specific dates. And I'll point the court to...
You can do that on rebuttal. You have rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. My name is Justin Shu from the law firm of Tarter, Quincy, and Drogan, counsel for 21 of the 24 respondents. There were 34 parties in the underlying action. 10 parties are stayed and have not been dismissed. Only 24 parties on this appeal. Let me address these issues somewhat out of order. I would like to address the practical point first, and that is 3211A. All the parties in New York are also parties in the California action. No dispute about that. All the claims asserted here, the identical claims asserted in this action, are also asserted in the California action. The California action is much, much further along. Discovery is basically completed. There's a trial day. There's going to be a resolution in that case. A resolution in that case will resolve all of the issues in this case. So that is the 3211A4 point. Now let me move to the personal jurisdiction issue.
Does it matter that even though the California action was started before the New York action, that the claims that A&M made in California were not asserted until after the New York action was started? Did I get that right?
You got it right, and yes, that is the distinction that they made. I don't believe that distinction makes any difference at all. The fact of the matter is that that case, the California case, started, I don't know, 2019. They filed their case
2021.
Sometime after that, a year and a half later in here. Now, also as a practical matter, the California court decided in April that the appellant would not be able to assert their claims here in New York. that they were stuck in litigating in New York in April of 2020, I believe. So at that time, they had to assert their counterclaims because California requires them to file their counterclaims, or otherwise they will lose the right to assert those claims. So yes, they filed their claims here in July, and then I guess they got some extension in California, and they filed their identical claims in California in September, but it makes no difference because that action in California started a long time ago, A. B, they will require in April, before they file the claims here, to file those compulsory counterclaims. So it makes no difference. So that's the 3211A4 point. The jurisdictional point, Your Honor, you correctly pointed out that they read the very last part of the forum selection clause. They forget, they totally ignore the specific and narrow agreement that the parties allege to have entered into. And the specific, I say specific, because the parties agree that the federal court sitting within the Southern District of New York shall have exclusive jurisdiction. So it is specific because it says any federal court within the Southern District of New York, not the Northern District of New York, and certainly not in the State Court of New York. And it says exclusive jurisdiction. Exclusive means excluding other courts, excluding New York State Court.
But did the third clause have relevancy if the Southern District lacks subject matter jurisdiction over the claims?
It makes no difference. The last clause is really a waiver. It follows everything that precedes it. And what precedes it is that the parties agree to have the federal court to have exclusive jurisdiction, number one. Number two, after the first semicolon of the clause, it says the parties agree to submit to the personal jurisdiction of the courts of the United States District Court for the Southern District of New York. And then, after the second semicolon,
now we
get to their point, which is that, well, we waive. Waive means, given what we agree to, we're not going to contest what we already agree to. The last clause does not give them a separate right to bring an action in the State Court of New York. It says nothing about the State Court of New York. And if you were to read this whole forum selection clause the way that they want you to read it, then you would have to read the exclusive jurisdiction language totally out of this clause stipulated to by the parties. That is the only way you would be able to adopt their position, to render this exclusive jurisdiction language superfluous. And one other point on that is there is a contrast between the pre-November agreement and the subsequent ones, because the subsequent ones provides an alternative jurisdiction.
That provides the state court jurisdiction.
Correct. So when the parties agreed to have the state court have personal jurisdiction, the parties knew how to write it. And by the way, this is their agreement. This is their form agreement. So to the extent that there's any ambiguity, that the agreement should be construed against them. I see that my time is up. My colleague may want to add.
Good afternoon, Your Honors. May it please the Court, John Scalzo, on behalf of 4 of the dismissed respondents. With respect to, start with the 3211A4 timing question Your Honor asked earlier. For purposes of 3211A4's first-in-time rule, the relevant question on timing is when the first court assumed jurisdiction over the appellant's claims, not when the appellant filed them in the second court. Because of the compulsory nature of the appellant's cross-claims in the California action, the City Trade Court of Appeals decision and the Errico case, which cites it, makes clear that the court in California assumed jurisdiction over those compulsory counterclaims the moment appellant's motion to dismiss in California was denied. That motion to dismiss was denied in April of 2021, before appellant filed their identical indemnification claims in this court.
So even though they hadn't been asserted yet because they were compulsory, they assumed jurisdiction of the yet-to-come.
That's absolutely correct, Your Honor, and that is why 3211A4 applies here, and it was within the IAS court's discretion, broad discretion, to dismiss the, what I'll call the non-mandatory forum selection clause defendants from the case. I also just briefly want to address the argument by appellant that there is no distinction between the dismissed defendants and the stayed defendants. That's not correct. The dismissed defendants are alleged to have signed the pre-November 2016 engagement letters with the alleged non-mandatory forum selection clause, whereas the stayed defendants are alleged to have signed the post-November 2016 engagement letters with the mandatory forum selection clause. The Flint-Koch case, which is actually cited in both parties' briefs, provides that a court should stay in action under 3211A4 when there is a risk that there won't be an alternative forum available. There is no such risk with respect to the dismissed defendants because even as appellant acknowledges, California is an available and alternative forum for its indemnification claims.
Thank you.
Thank you.
Good afternoon. I'd just like to address a few points on rebuttal. First, Respondents' Counsel suggested that to read the forum selection clauses in a way that would permit state court jurisdiction would effectively render the exclusive provision of the Southern District of New York superfluous. That is not correct. That is not what we're arguing. We are not arguing that there is exclusive jurisdiction in New York State Court. It is clear that what would happen is if there was no subject matter, if there was subject matter jurisdiction in federal court, the claim would have proceeded in federal, not state court. It is only when there is no subject matter jurisdiction in federal court that you look to alternative forums. The waiver to objections to jurisdiction in the state of New York operated to provide alternative jurisdiction in New York State Court, along with any other jurisdiction that might have personal jurisdiction over the parties where there is no subject matter jurisdiction in federal court. The parties to the agreements knew how to write the Southern District of New York. They wrote it over and over in that provision. If they intended the waiver to operate only in the Southern District of New York, they could have said that and they could have written that. Second, I'd like to address the issue with respect to 3211A4. The respondents do not address the clear holding of the trial court where, which was incorporated by reference in the decision in which the trial court stated that if it did not dismiss for lack of jurisdiction, it would stay, not dismiss, the claims against the dismissed entities under 3211A4. If the court stayed those claims along with the other defendants in this case, there is no risk of waste of resources, as the parties have argued.
Thank you.
Thank you.
Thank you all. Stanley versus 1854 Cedar Avenue.
May it please the court. My name is David Rutherford. I represent the defendant appellants in this appeal. This is an appeal about duty. duty to prevent suicide.
Counsel, I agree with you that the issue here is duty, and I have some questions for you about duty. As I read the record, it seems to me that the decedent was asked by your clients to complete a form called My Crisis Plan at or around the time he signed the lease, right?
Correct.
Okay, and it also seems to me that your emergency protocol guidelines require that when there is a psychological emergency, any individual working for your client is supposed to first notify a supervisor and then refer to the crisis management plan, correct?
Correct.
And I didn't see anything in the record that indicated that as Mr. Fleming's problems increased, that anybody employed by your client looked for his crisis management plan at all, is there?
Well, there was...
Is there any evidence that anybody looked for the crisis management plan?
That's not in the record, Your Honor. However, take the day before when Mr. Fleming spoke to Hiawatha Collins. Mr. Collins and he had a discussion about how he was feeling.
But there's no indication that Mr. Collins looked at Mr. Fleming's crisis management plan, is there?
Not that he looked at the plan, but the two of them developed a plan, in fact. What they did was, he said he was...
But he didn't look at the existing plan. And that's what your own internal rules require, don't they?
No, I don't think it requires to actually look at the plan. It requires to have a plan, and there was a plan. There's a plan in place because the two of them decided, remember, our client does not provide these services, these mental health services. They broker them.
Counsel, I guess the question is, because of the requirement that when a person signs the lease, they have to execute this crisis management plan, HIPAA forms, and other things, did your client then create a heightened duty for itself that would maybe put it in the category where we would find that they were liable for the suicide?
Not in the least, because they don't profess to provide those plans. They help the individual get to the people who can help them. So, as I was trying to say before, the day before, he says, the decedent says that he's going through some things, he needs to talk to someone. They make arrangements that we're going to help him the following day go and see somebody.
But isn't the point of having a crisis management plan is that that's a plan that the person adopts at a time when they're not in crisis, when they're thinking clearly, as opposed to how they might be thinking less clearly at a time of crisis?
Well, we're not providing those crisis services.
Well, I understand, but that's why, okay, so what is the reason that you asked Mr. Fleming and other residents, I assume, to create a crisis management plan?
So that we can help them get to who they need to get to.
In other words, when they fill out the forms, you have a list of people who you recommend, or you have types of people who you recommend and guide them to those people?
Yeah, we don't.
Or is it something else?
We help guide them to the people.
But in the case of Mr. Fleming, he indicated that in the event of a crisis, he wanted to be either taken to the nearest hospital or to have his father contacted. And you didn't, no one in your facility did, in your clients employed, did either of those things, right?
In point of fact, he said he did not want to go to the hospital. He did not want to go to the emergency room. He specifically said that, and we can't force him to do that.
He said that, right?
Regardless, we don't have a duty. If he said he wanted to do that, then we would have helped him do that. But we don't have an independent duty to take him there. So
let me ask you a different question. You accept tenants like Mr. Fleming who have a history of suicidal ideation.
Correct.
Do you think that you owe any duty to those individuals to perhaps bar them access to the roof, which is not guarded by a very high fence?
No, we don't, because we don't profess to have that heightened level that you're talking about. We're very clear, and the record is abundantly clear that we only broker these services. And so we were offering to broker them, and in fact, that was the plan the day before. That they
So
were going
may I
to
just
do.
ask you, just for clarity, places, hospitals and jails that have custody of individuals have a duty. That's clear.
Correct.
The other would be, I guess, where there is an institution or mental health professional with sufficient expertise to detect suicidal tendencies and with the control necessary to care for the person's well-being. That's the other. With this individual who was there, were there any, just for clarification, I think you already spoke to this, but were there any special services provided by professionals on the premises?
Absolutely not.
Was that said to the tenants when they came in? Was there any confusion about whether tenants knew? Did the facility ever hold themselves out as a place that provided those kinds of services to the tenant?
No, they never held themselves
Counsel,
out.
what
I have
about the
just
state?
one other question. With regard to this kinds of security or the way the facility was designed, people are, this is a tendency. Are people choosing to be in this facility of their own free will?
Yes.
So they understand whether it has a balcony or it has an open roof, or they might actually choose a place that has a green space on a roof. Is that they understand what it is? They're not forced to be in that
Exactly.
space?
They apply to go there.
They apply
It's
to be
voluntary, and in fact, he had lived there for 6 months before this happened, okay? And we never held ourselves out, and that's what separates us from a lot of the different cases where you have...
When you say that you didn't hold yourself
Just
out...
let me hear the rest of the question.
Sorry.
The answer.
Where you
rather.
have psychiatrists who don't diagnose it, or where someone is the... In fact, the case that's cited in the briefs, this Doe versus Langner case, that defendant was the exclusive mental health provider for the person who did this, and that's what created the duty. Here, there's no question we're a broker. We don't have any psychiatrists on staff. We don't have we don't have the people that would, as you cited, have sufficient expertise to detect suicidal tendencies. That's clear. Everybody knew that.
But counsel, then how do you explain the sentence on the application form that states, quote, "There will be social service staff on site in the building," close quote. Isn't that something from which an applicant could assume that you were going to have social service staff on site from who might be expected to have some expertise?
No, I don't think so. We only had...
You don't dispute that that sentence is on the application?
I don't dispute that the application says that. My point is that there was no one, and we brokered these services and got them to the people you're talking about. So if someone...
Is social services the same as mental health services, or is there a difference?
There's a difference. And there's certainly no one with expertise on preventing suicides. I mean, that's something that even psychiatrists struggle with.
So how do you define the social services people that you're supposed to have on? Who are those?
We had two types. One was service coordinators, and those were the so-called brokers. They would, if you needed a mental health professional, they'd help you get to one. And then you would develop your own relationship with that mental health professional. The second type of person we had were called harm reduction specialists. Now, what is a harm reduction specialist? A harm reduction specialist is a service coordinator, except they have an added life experience. For instance, they might have been a former drug addict, and so they might be able to give you an extra level of help in terms of, I can deal with drug addiction because I've been there. I can recommend you. So,
is that an expertise?
No, that's an experience. That's not, there's no extra schooling, there's nothing like that. It's just someone you could maybe identify a little more with because they've gone through the...
I asked you the question because expertise is what's in the case law.
Right.
That's why, yes.
Absolutely correct. And we don't have any experts. There's no experts there whatsoever.
So these two categories of social service people that you had on, were they on 24 hours a day, or they're just there 9 to 5, Monday to
Exactly.
Friday?
9 to 5, and at night, there was one person, he's a receptionist, security guy at the front lobby, and tragically, this person jumped off at 5 a.m. The only person on staff was a receptionist.
Was there any question, was there any question about the availability of anyone? I understand that you said that these are service coordinators. They are not professionals. They are not people with advanced degrees or special certificates for such treatment, right?
Correct.
But was there any question that anyone would be available beyond the hours of 9 to 5, since this is, I mean, it's not a residence, but it's an apartment building?
No, you wouldn't be able to contact someone. So if, for instance, they thought that if he walked down and said, I'm going to kill myself, right now, I'm going up, and you could call 911 or something like that. But that's not really the facts of this case.
Well,
Counsel, I'm sorry, let me just ask one more question. Following up what you said earlier about the limitations of the skills of the people who were working there, if there was no expectation that anybody on staff would perform any functions with regard other than referral, why is it that your emergency protocol guidelines require that safety and emergency response training sessions be conducted regularly with the entire staff?
That's so that you could respond, if you saw something like this, you could respond by referring. Again, this is all referrals. You're talking about a situation where we have the staff, the money, the funding, the staff to have psychiatrists, people with expertise on preventing suicide. That's not what we are. That's not what we represented ourselves to be. That's not the experience that the factual record shows. Look no farther, as I mentioned before, than the day before. Our person didn't say, hey, let's meet tomorrow and let's have a counseling session. No, what he said was, let me help you get to someone tomorrow.
Didn't he also say to the person at the front desk, if you see Mr. Fleming doing anything odd, you should call 911?
A little more than just odd, but
I was paraphrasing.
But he didn't. And I went through that in my brief, which I'm happy to go through again here if you'd like.
Sir, I'm curious, we keep using the word expertise, but was that really what was called for here in the context? They were in a facility that was supportive housing for, among others, individuals with mental health issues. This individual had a disclosed schizophrenic condition, a disclosed prior suicidal ideation. There was, viewing the record in the light most favorable to your friend, an indication that several hours before he committed suicide, he was appearing to be acting strange or odd with one of the harm reduction specialists. There is then allegedly a comment passed from this decedent's visitor to someone working there that he was indicating he might hurt himself, that he was cutting himself and pouring alcohol on himself. Where is expertise needed to know that some form of intervention is needed and that intervention can be summoned from off premises?
The problem with that argument is you're skipping duty.
I'm not skipping duty.
Well, you are, because there's no duty to prevent someone from committing suicide unless one of these two exceptions is met. And you don't meet either exception. The first one is clear. We're not even talking about that. It's not a jail or a hospital. The second one requires expertise. That's why you never get to beyond the duty here.
And I think that I'm glad you brought that up, because I think that this really gets to something that's bothering me about this case. Where does this special rule for duty come in suicide cases, as opposed to the common duty principles and elements we would consider under Church, under Palfka, under all the various Court of Appeals cases that are out there that tell us we have to balance different societal and policy and economic issues in drawing tort duty? What's the genesis of this special duty rule to prevent suicide?
This court had it 30 years ago in Saigon versus New York. This court set the duty. They said there's only 2 instances. Otherwise, I have no duty. Unless I meet one of these 2 exceptions, that this court has held, unless I meet that, there's no duty.
Does it matter that, as you indicated, that that case was decided 30 years ago? This type of housing facility might not have been considered. And now maybe we need to expand Saigon and think about, well, there should be, because of the nature of how people come to stay, or what's required of them, rather, in order to get this kind of housing, that there is this now third category that we should be considering.
A, this kind of housing was around 30 years ago, but B, even more importantly, this court has revisited this duty thing many times. Revisited it in the 90s, revisited it probably within the last couple of years in cases.
Oftentimes in the context of a municipal defendant, where we often have tort rules that are more favorable to municipalities than we do non-municipal actors.
Well, no, there's actually been in non-municipal cases just as well. But
Okay, name me one.
well, it was cited in Ferrer versus River Bay.
Okay.
Webb versus Mueller, which is cited in the briefs. In both of those cases, you met either the first exception or the second one. So take Webb versus Mueller, in which is a SUNY student who killed themselves. Those people were specifically trained, the staff, in how to recognize people who were suicidal, how to deal with it, how to coax out of them that they're not just, for instance, in this case, the decedent said, he was asked repeatedly, are you okay? And he said, yeah, I'm okay, there's no issues. In the SUNY...
But at the time he said that, he was standing outside the barrier on the top of the roof, right?
Where he could go. And what did he say? Okay, first of all, are we going to put on a receptionist the duty to figure out whether someone is going to kill themselves? And the receptionist saw the person on the roof, they went up there, and what did they say? They asked him, are you okay? Yes. What are you doing? Why are you over there? And he said, I'm just checking this out. Okay. So, you sure you're okay? Gives him a fist bump. Now this is a security guard. So he's supposed to diagnose that when he says, I'm looking out there, or I'm okay, that's not sufficient? I mean, what is the duty that we're going to put on ordinary individuals? Because that's not what this court has held for the last 30 years.
I'd like you to just go back to what you were talking about in the Webb case, where you said the staff was specifically, you were going to make a comparison, I think, but maybe you weren't.
Well, I was saying they were trained to, even if someone says I'm fine, to actually
okay, so you made
coax it out of them and figure it out. And they said that created the heightened duty because they had that expertise. Now,
thank you.
No one had the expertise, but certainly not the receptionist.
Okay. Any other questions? I mean, you may have a lot of questions, but right now we could go on all afternoon. Thank you. Counsel.
Good afternoon. Daniel Lieven-Steinberg for respondent. Not only was there a history of suicidal ideation here, the manager or the harm reduction specialist the day before the decedent jumped off the building concluded that he was a threat to harm himself, and she was supposed to advise the security team in the lobby, if anything untoward occurs, please call 911 immediately.
Counsel, I'd like to focus specifically on duty.
Okay.
So it seems to me that you are asking that we impose a duty on defendants. What are the parameters of the duty that you are asking us to impose on defendants?
Based on the second prong that Judge Renwick talked about in the Saigon case, if there is sufficient expertise and necessary control to some degree over the plaintiff, then a duty attaches.
But what are the parameters of the duty?
The parameters are to take some steps, Your Honor, any type of step to try and prevent this awful situation from occurring.
But aren't Aren't you overstepping the issue about the level of expertise that a person has to have when for that duty to arise in the first place?
It didn't take a level of expertise because there was somebody that
I understand, but doesn't the case law require that to hold the person, to hold the place liable, there does have to be a person who had the expertise who failed to do it as a
But I think the question of what expertise is here, it's not, I don't believe that the courts would impose a requirement that there be a psychologist or a psychiatrist
But
on
it says
staff
mental
24 hours
health
a day.
professional,
have a-
mental health professional with sufficient expertise. Not even just a mental health professional, but a mental health professional with sufficient expertise to detect suicidal tendencies.
Correct. That is what the Seigen case says. And in this case, we have a harm reduction specialist with life experience who's been working at the facility.
Is that sufficient expertise? Because maybe I'm misunderstanding the definition of this harm reduction specialist as someone who has been through certain life experiences, but that life experience doesn't give you a heightened duty. You have your life experience, but you can't, how do you, expertise is usually some kind of educational expertise, not necessarily you've lived through it.
Yes, Your Honor, but they also go through training to be employed, as indicated in the admission documents, that there is training to deal with people just like the decedent. He had a long history, not just of suicidal ideation, but actual attempts.
Sir, don't we have to view that word expertise in the context of the cases in which it was made? And normally it was an institutional type actor, whether it be a hospital, a prison, a law enforcement. And so this to me really falls in between those type of actors, the municipal governmental actors that may have that expertise, and a proprietary landlord. This one strikes me as somewhere in the middle.
I agree.
And so I guess fundamentally, first of all, are you asking us to simply apply cyber and the Benitez rule? And that you fit within, I guess, the second aspect of that rule?
No, what we're saying, Your Honor, is, I mean, if you look at the Ferrer case, that's a River Bay, that was a case involving a girl at River Bay involving security officers there. That was not a municipal entity, that was the River Bay case, which is cited in our papers. A 12-year-old girl who had been sexually assaulted, and the security at River Bay segregated her in a room on the 26th floor in an apartment of her friend. And they were somewhat asking her to press charges against the perpetrators of this crime.
But they were basically imprisoning her, weren't they?
But she wasn't in a prison or a hospital. I mean, there was some degree of coercion, I guess, there, and she jumped out the window.
But again, we're sort of talking about custody, in the custody or control in the classic sense, or expertise in the professional sense, right? Those are the way these cases have come up. This is not that case, in my view. This is something short of that.
I agree.
And so, do we simply apply our Seigen and Benitez authority and look to see whether your allegations and evidence have satisfied that second aspect of that line of authority?
No, I think there's a broader duty here, Your Honor. I think that, no, that you can't just look at Seigen in and of itself and say that the harm reduction specialist is or is not an expert. That's not the question. The question is there is a duty because of the duty.
We got to find there's a duty, and then we got to define the scope of that duty. So where would we draw the line in this particular case as to the scope of the defendant's duty?
The defendant's duty is that once the patient or the person is living at the facility, they're aware of the history, they have a harm reduction specialist, they have an emergency protocol, they have 911 who is supposed to be called. All of that would indicate in and of itself.
So then your statement, your argument to us is that we need to expand it so where a facility might hold themselves out as this kind of more than just supportive housing, but where they're saying we can get you to certain services, that in of itself creates this heightened duty?
But they were doing more than just being brokers here, though, Your Honor. They were doing more than that. They had a harm reduction specialist on staff. They had all these people at the facility. They recorded all of this. They had my client's medical records.
But the harm reduction specialist I just want to make sure, was the harm reduction specialist 24 hours?
No, in this case, I believe that the harm reduction specialist left around 6 p.m. with instructions to the security staff that if something happens or there's some indication of self-harm, immediately call 911. And not only is there an indication that my client's girlfriend, the decedent's girlfriend, comes down at later the next day, the morning, and says he's suicidal. He's going to kill himself. He's pouring alcohol over his head. The next thing they know, he's on the roof.
So that should have been, if he does anything out of the ordinary, odd, of concern, call 911. So he had an obligation not to go up and say,
Your
how
Honor,
are you, but to make the phone call.
Precisely. This is such an egregious case of having actual knowledge of this poor man trying to kill himself that I think the duty can be expanded beyond the limiting language
So
of
then,
psych.
I guess what would happen is that no facility would accept someone who was suicidal if they would have the potential.
Not at all, but
I mean, would that create that kind of effect where they would?
If there's a duty, there should be a duty to protect these people.
So then I guess this is the question I keep asking. You are in fact asking us to expand.
Yes, I guess so then. Yes, Your Honor.
So you're asking us to basically create a third category of duty in addition to the two delineated in Saigen?
No, Your Honor, look, I think that under Saigen, there is a duty under Saigen based on
You think we can reach it under Saigen, but if we conclude that there isn't the kind of expertise described in Saigen, would you then be asking us to create another category of duty?
Yes.
And would that tying into something Justice Renwick just was touching on, and again, under common law rules, ascertaining duty and the scope thereof, we have to consider, among many things, the effect of imposing that duty on society, on institutional actors, and would imposing a duty here dissuade institutions or not-for-profit organizations from offering the type of supportive housing that your friend's client offers?
I don't think so, Judge. There should be look, in a facility such as this, there should be some degree of, you can't just say, we're not professionals, we have no idea what's going on, we're simply brokers, when somebody is at the facility with a known history that you've elicited. They're the ones who had my client sign the application. They're the ones who provided harm reduction specialists. They're the ones who provided all of these services to the decedent. And then to turn around and say, well, you know what, I'm sorry that you jumped off the roof. We knew you were suicidal. We knew you were on the roof. We knew you were outside on the edge of the roof, outside the fencing. By the way, this is all on video. The security guard goes up and gives my guy a high five and turns around. And 2 minutes later, my guy does a Superman off the side of the building. There should be a duty here, some duty, even a minimal duty, to call the police, do something.
Thank you.
Thank you, Judge.
I think that it really comes down to, under existing case law, it seems pretty clear there is no duty here, and that you would have to go.
The case law can change, right? Because, I mean, is it right that your facility would promote yourself in this manner, requiring these documents to be signed, saying that there's this harm reduction specialist on site, and then when something happens, say, that's too bad,
The end result will be that there won't be housing for people like this. That's the end result. There's not a possibility that you can fund something like this adequately. I mean,
Well, of course, there could be a societal choice to fund agencies like this adequately. One can imagine such a society. Maybe this isn't it, but it's impossible.
but that's not. But they never held themselves out to be that, ever. Well, because where does the duty end? I mean, this is the quandary here. I mean, and, you know, psychiatrists themselves have a hard enough time figuring out when somebody's going to kill themselves. And so
applicants took it to mean when your application form says that you have social service people present in the facility?
I think they took it to mean exactly what happened the day before, which is, if you say, hey, I'm going through some things, I might need to talk to someone, hey, I can help you. Come in tomorrow morning, we'll find somebody for you. And if your friend can't take you, I'll take you. But it was always to find someone else. And I want to also just address this part about the girlfriend and actual knowledge of suicide. He never said to anyone he was going to kill himself, ever. There was 3 separate instances. The only part where someone said he's suicidal is the girlfriend. So what happened? The girlfriend says, hey, he's suicidal. He's pouring alcohol on himself. He's cutting himself.
And she doesn't call the police. She doesn't call 911.
If she's so concerned, she's leaving. She doesn't care. But even more importantly, she calls up to get her water bottle. He comes down. And does he look like he has alcohol in him? No. Does he look like he's been cutting himself? No. Does he say he's okay?
To the front desk person who you say has no skills at all.
Well, our front desk person, that's his observation. So now you're going to say the ordinary person should have the skills to know that that's not really what's going on here? I mean, when we talked about the SUNY case, what they said was, defendants were trained to deal with residents in crisis and specifically how to extract relevant and truthful information from a student who may be considering suicide and what to do if the student was determined to be suicidal. They were trained to analyze the student's body language and words in order to gain insight into his mental state. Are we going to put that burden on a receptionist?
Well, you say your records, your policies say that you're going to have emergency response training sessions.
For
emergency response training session for all of the staff?
That's for service coordinators and harm reduction specialists.
It's supposed to be for all staff.
I think the record's clear that the receptionist didn't have expertise. I mean, that's not even anywhere in the record.
Thank you. Thank you both. Gomez versus Samaritan Daytop Village. You may begin.
Good afternoon, Your Honors. My name is Tim Norton on behalf of the appellant, Jonathan Gomez. It's our contention that the lower court erred in dismissing our case here by finding that defendants met their prima facie burden to establish that there was not constructive notice in this defective staircase. I'd like to point out to this court the Conklin versus 505-12 7th Avenue. This court's decision from 2018, I think, is particularly illuminating here. In that case, the injured plaintiff fell from a landing of the stairs which collapsed. And the evidence that was presented in that case is very similar to this one. There was a series of photographs in that case and in this one that indicated the stairs in a decrepit condition, very rusted.
The stairs are in awful condition in this case. Did he tell the owners, the actual owners here, as opposed to the previous owners?
He told who he was instructed to tell, which was his direct supervisor, Miguel, in this case.
Wasn't Miguel employed by the former owner? I mean, my understanding was that Samaritan Daytop Village didn't take ownership or control until 2 months before. Correct. But isn't it true that there's no evidence that they ever did an inspection to see what the stairs look like?
That's correct, Your Honor. So even putting aside if there's no actual notice from the complaint, there's no evidence here to meet the evidentiary burden on these types of motions that there was an inspection of the stairs, any cleaning of the stairs, any maintenance activities of the stairs. There's nothing here. There was an inspection report done by Sarah initially, which was ruled inadmissible below, and it's clearly inadmissible here. I mean, it was a general statement, and it was based on hearsay, and below it wasn't even considered. The only other thing I would like to add, so I think on that grounds alone there's issues of fact. The only other thing I would like to add is that the lighting issue was also raised below, and the court ignored it below because the entire defense seemed to be here, well, this is a latent defect, so even regular inspections, are not necessary to meet our evidentiary burden. The lighting is clearly not a latent defect. And to the extent that there's arguments that plaintiff didn't complain about the lighting being a proximate cause of his accident and contributing, in our brief, we reference his exact testimony saying that...
there was a question during a deposition, did the light
Exactly.
any
I have-
effect, and
yeah, I
didn't you
have
say
the site.
yes?
What other complaints did you make? No lights in the building, walking around in pitch black darkness. And then specifically with contributing, did the lack of light prevent you from placing your foot on the step? I would say it definitely contributed. How did it contribute? There was no light. It was so dark, it makes it harder to see. So the idea that that didn't contribute to the accident in and of itself raises an issue of fact, and that's certainly not a latent defect. I see my time is up.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. My name is Diana Reynoso with the law firm of Black, Margie, and Sanford on behalf of the respondent, Samaritan Daytop.
So this is a step that came up. I mean, the slab actually came up when he
Yes,
stepped
according-
on it. So how is that something, and I think it's, I don't think you disagree that the owners didn't do an inspection.
Yeah, that's correct.
That's correct. So how is it that they wouldn't, there isn't constructive notice, or they shouldn't have had notice of this step that one could, that it literally pulled up?
Well, this is, like, the lower court correctly found that this is a latent defect.
How is that latent? That's my point. How is a step that moves and that you can actually pull up, how is
Because-
that latent?
Okay, according to the appellant's testimony, his complaints were that the steps were loose, chipping, unstable, and it would wiggle. And by chipping, he meant that it would just feel unstable. And
Well,
when
if
asked-
a step is, what did you say, moves, wiggles, or whatever you said, wiggles, I think you said? or
Wiggle,
loose?
yes, that's what he said.
Loose? I mean, doesn't that indicate an issue? Is that supposed to happen is a step supposed to wiggle?
They're not supposed to wiggle, but it wouldn't be visible upon an inspection.
Why not? If you go to a step and you check it, I mean, your job when you go to a step, if you're looking, is not just to look with your eyes. If you step on the step and it moves or it wiggles, that would indicate that there's something wrong.
That's correct, Your Honor. I agree with you there. If Samaritan had knowledge about
But
this
wasn't it their
complaint-
responsibility to have knowledge of what existed in their building?
Well, they were in a transition period, and yeah, they were, the prior management was narco, and they were closing down, it was like a,
When you say they were in a transition period,
they were taking,
were they the lessee or the owner at that point?
yes.
So what does it mean they were in a transition period? Why didn't they become responsible from the time they became the owner?
Well, they are responsible, Your Honor.
What is it? But your brief suggests that we should, in fact, you specifically said that they had not assumed full control of the building. I don't understand what that means. If they own it, then they have full control of it. Why should we let them off because it was the first month that they owned it, or second month that they
Well, they weren't aware of the issue, Your Honor. You know,
aware of any doctrine that says in the first 2 months that an owner owns a building, it has less responsibility?
no, Your Honor, but, no, not fully, Your Honor, because this, can I finish my thought?
Yes.
Just because this is a latent defect, it wasn't visible. So even when they inspected the property initially, it's not something you're going to see just on a visual inspection.
On a visual inspection, but that's not an inspection of a staircase.
Correct.
Thank you.
Thank you.
Good afternoon. Excuse me, Jonathan Schaub for the Sarah Security Respondent. I want to talk about that inspection issue. The testimony is that the people traverse these stairs repeatedly without feeling or noticing any of these issues. Ms. Greco, who worked for Samaritan, was at the premises, walked up and down the stairs, and never had an issue. The counselors at the facility never reported an issue with the stairs. The residents never reported any issues with the stairs.
This particular individual who fell did report an issue to the previous owners, didn't he?
Allegedly to someone named Miguel, who never actually, there's no testimony that Miguel ever was actually employed by that facility. That was done after the litigation commenced, and in the 2 months between the September period and the November accident, he never reported it to Sarah Security.
Well, do you agree on this issue of visual inspection, that it wouldn't have been discovered? I mean,
No, it would not have been discovered on a visual inspection, and then I know that we were talking
is that
about,
the extent of inspection when
in this case, it's whether it would have been discoverable upon a reasonable inspection, and we submit.
Right, so what's reasonable when you're inspecting stairs? Just looking at them or something else?
Well, even if there was something else required, you obviously can't lift up the entire stair
Well,
to test
wouldn't
it.
that be an issue of fact? Because we have pictures of the stairs, and they look somewhat rusty and decrepit, like the plaintiff testified. That's, I took a look at them. Now, I'm not saying that means you're responsible, but I'm saying, doesn't that at least raise an issue of fact that has to go to a jury as to whether or not, had you done an inspection during those 2 months, that you might have been able to see that without touching and, having 3,000 people come in, you might have been able to look at it and see it. You're saying there's no way. I'm saying, isn't that an issue of fact?
I just want to push back a little bit on that premise about the rustiness. It was actually marble steps, and marble is a very porous substance, so it's not like they were rusted through. It's just the coloration of marble. On the issue of the inspection, I would point out, again, that the Sarah security personnel had to go up those stairs every hour, so that's 24 times in a day, and had to go up and down, so it's 48 times. So they went up and down those stairs thousands of times, and no one ever reported any movement. So it's not clear, or there's no way to know what an inspection would have revealed that those thousands of trips didn't reveal. We're talking about whether these stairs moved or not, and we have the testimony that no one reported these issues. And in fact, plaintiff himself, on the day of the accident, said he went up and down 4 times and never felt the stair lift up. So there's nothing that this inspection would have revealed that wasn't determined by the people walking up and down the stairs during the course of this work.
Well, one would hope that one who is inspecting stairs has more than just the knowledge of an average person taking the stairs, and would know how to test a stair for how secure it was, so that a stair wouldn't just lift up. I mean, for a stair to become completely disengaged, and I understand these are these slabs, that takes a little bit, right? I think one who knows how to inspect, who does an inspection, would be able to find that.
I appreciate that, Justice Renwick, but the test is whether it was visible and apparent. And again, there is no evidence that it was visible or apparent, because we have, again, a wobbly stair wouldn't be visible. And as to whether it would be apparent, we have these thousands of trips up and down the stairs without any reported incidents. This same type of event didn't happen. Plaintiff himself testified it never lifted up. And I know I'm over time, but briefly on the lighting issue, there is no proximate cause or causal connection here. This is not an accident where the plaintiff missed a stair. He stepped on the stairs.
He said that it made it harder for him to see. He did answer that question. It was a little harder to see as I was walking down because the lighting was bad and I had complained about
But that doesn't tie it to what happened here. The step lifted up. That doesn't, because he said he couldn't see the stair, that doesn't have anything to do with what actually happened in this accident. I agree. Had he missed the stair and the lighting was bad, that would have been an issue. And also just on the factual predicate, he testified that the lighting wasn't so bad that he couldn't see a syringe on the ground. So there was lighting that was visible, and there's no causal connection between that lighting and the stair lifting up. And unless the court has any further questions, we'll rest on our brief.
Thank you.
I'll just be extremely brief. Just with respect to the records, just to give context to the court, Amy Greco, who was the Assistant Director of Permanent Supportive Housing for Samaritan Village, she didn't even know if there was a ticket created for the actual accident itself, or if she notified the maintenance supervisor. So it's very clear that maybe in this transition period or whatnot, there was not sufficient record keeping going on at this time. And just not to reiterate anything that's already been raised by the court, but with respect to the lighting issue, again, the testimony speaks for itself, that clearly he had difficulty navigating the stairs. The bulbs were not changed. There was no maintenance people in the area ever doing any work with that. Unless there's any questions, thank you very much for your time.
Thank you. Thank you all. Williams versus New York City Department of Transportation.
Good afternoon, ladies and gentlemen. My name is Marcelo Buitrago, Buitrago & Associates. You guys clearly left the best for last, so I'll try to use my time as best as possible. I am moving to reverse the lower court's decision for a summary judgment motion that was granted for the City of New York regarding a trip and fall where it didn't address the sewer basin. So I'll address the most important part. It is the burden of the defendant in this case to prove that there was no prior written notice. Normally, it's on the plaintiff to prove prior written notice. But here, the defendant moved for summary judgment on that exact issue. And they must prove that there is no prior written notice. And they failed to do that. And I have 2 points to exemplify that. One, the court cites and quotes saying that the witness that was deposed by me personally, Mr. Hammond, that he testified in his testimony contradicted the records that were submitted, and that his testimony was vague and conclusive and things of that sort. The reality is this is a defendant's witness. So the court is using that testimony against the plaintiff, which is inaccurate. More importantly, that same witness, Mr. Hannon, again, from the defendant, testified that the report that was generated on April 2nd precipitated the actual work order that was generated on April 17th. Now, the city's saying there are no paper trails. So are we to believe that from April 2nd to April 17th, when the actual work order was generated, nobody spoke to them? Nobody said on April 2nd, hey, go check that site. Go to that location. Here's a note. Specifically, the witness testified that notes are taken. So how is it possible that on April 17th, coincidentally, the city goes to the exact same location that was inspected on April 2nd through the project and decides that repair is needed? That's one. The second part of it is the defendants submit on Exhibit 233 of their package, of the transcript, and defendant's own affidavit in opposition on page 33, they submit the affidavit from Mr. Collins. Mr. Collins is the only individual who's actually part of the inspections, part of this project that does the inspections. He is the perfect witness that should have addressed the contradictions or the statements made by Mr. Hannon at the deposition. Specifically, Mr. Collins should have said, or could have said, we do not write reports. I'm in charge of this project. We don't write reports. We don't make notes. He never said that. In his entire affidavit, at no time does he address if, in fact, there is or there isn't a paper trail created. It is defendant's burden to prove that, and they fail to do it. Am I going to automatically win at trial? I may not. And I'm aware of that because I need to still prove prior written notice. But the fact is that motion should not have been granted at this stage.
Thank you.
That's just me.